Okay, Mr. DeVolder.
Thank you, Your Honor, and may it please the court. This is an appeal from a district court order dismissing my client, Deborah McFadden's wrongful death tort claim against the state of Iowa on the district court's finding and affirmed by the Court of Appeals that Ms. McFadden didn't properly present her claim to the State Appeal Board. And the reason that the district court in the Court of Appeals determined the single reason that the claim was improperly presented was Ms. McFadden's purported failure to identify herself as administrator of her deceased husband's Charles estate, even though the record is undisputed that at all material times here, Deborah McFadden indeed had the status of administrator of her deceased husband's estate. Now, the singular authority cited by the previous courts who ruled on this issue is the definition of claimant in the Iowa Tort Claims Act, as well as its interpretive regulations, and mainly the case of the estate of Voss. And the estate of the Voss case, which was in fact an ITCA case, is consistent with non-ITC case wrongful death cases such as the state of Dyer and Pearson v. Anthony, other cases cited in the briefs, that hold that the issue is not whether the plaintiff or claimant claims a status, in this case administrator. The issue in common sense is, does the plaintiff or claimant have that status as administrator? And it's undisputed in this case that Ms. McFadden, of course, had that status and obtained that status within less than 2 months from the time of her husband's motor vehicle accident death. So,
she had counsel at the time she submitted the administrative claim. Not you, but she had counsel, right?
she did, Your Honor.
And why didn't they just say administrator on the form?
Well, you know, I suppose they could have. I mean, there was nothing that prevented them from putting the term administrator. But you know, make an interesting point. It's supposed to be a streamlined process at the State Appeal Board agency, and some people have lawyers, others don't. And I don't know of a distinction. Well, if you have a lawyer, you gotta, you know, jump through those formalistic hoops. But if you don't have a lawyer, perhaps we'll excuse you. But you know, if you look at the State Appeal Board claim form and affidavit, which is the uniform one that the State Appeal Board asks, and it appears at pages 10 to 16 of the appendix. You know, it doesn't ask for representative capacities in that claim form. What it does is it asks for the name of the claimant, the full name of the claimant, and it asks for the claimant's date of birth. It doesn't say, do you have a representative capacity? When did you obtain that representative capacity?
I think that's a fair point. And I also noticed that in the administrative code for these claims, it says a claim shall state the name, address, telephone number, and age of the person making the claim, but it doesn't require that the, at least as I read it, I'm going to ask the state about this in a minute, it doesn't require that the capacity be disclosed.
And you're correct. In the claim form, the streamlined claim form reflects the agency's own regulation concerning that position. And why would it not? No.
You know, in most cases, I would think the widow would be the administrator of her deceased husband's estate, but not always. And wouldn't the state run the risk if they just paid the claim as presented, that somebody else could come forward and say, hey, by the way, I'm the estate administrator. That, you know, other family member didn't have that capacity. Now there's a risk of double payment exposure.
Yeah, and indeed, Voss, the Voss court implicated that on the presentment requirements is twofold. And Mr. Justice, you just mentioned both of them, to make sure that the state's dealing with the correct claimant or claimants for the particular claim, as well as for the state to be able, if it chooses to do so, settle the claim and obtain an appropriate release. But in this case, Your Honor, the state could have always, if there was a question about it, made inquiry before the release. I'm sure if, just like in the Gavin case in Massachusetts, at least with respect to the presentment requirement, I find it hard to believe that the state is going to, if it settles the claim, draft a release that doesn't have the appropriate release language and terms and capacity in it.
Isn't it more fundamental, though? How do you settle a claim with an estate without getting a court order? You can't. So how can the state risk double payment if you need a court order approving the settlement?
You can. I'm just taking Justice Waterman's presumption that would the state jump in and do it. I suppose if the state was extremely negligent, they could accept paper signed by anyone and claim that they've got a settlement. But even if you're dealing with the estate, from a legal standpoint, you are correct.
And I
think it has to.
And I think that's one of my problems with the old Voss case is that I don't see any way the state can pay double claims on the darn thing or pay the wrong party, because anybody who did this work knows that you can't settle a claim against an estate without having the probate court approve the settlement.
And that is correct. You are correct that the probate court must approve a settlement in order for that settlement to be binding with respect to the estate.
Counsel, what about the administrative framework here, the claim process for Iowa tort claims, should lead us to the conclusion that the Attorney General shouldn't be able to just lay in the weeds after a claim form is filed that doesn't identify the representative capacity and just wait and see what happens, instead of, as you've suggested, that we should require the Attorney General to make inquiry of Mrs. McFadden. Show us your authority to make this claim on behalf of the estate.
I mean, there's nothing that's prohibiting the state, to the extent it has a question on this streamlined process, to make sure it's dealing with the appropriate claimant. In fact, it's a very easy inquiry. Show me the letters of appointment. It can be that simple.
But I guess what about the nature of the administrative process should require us to put that burden or that duty on the state to make that inquiry if it's not shown on the face of the claim?
The state has set up a streamlined administrative process. And I've discussed the form, what it requires, and Justice Mansfield pointed out what the requirement is on that. But obviously, it's a form that the state has set up to have a streamlined process, and it is somewhat distasteful if you want to take the evil Attorney General or state view. Well, let's just sit back here because the administrator doesn't appear on this form. We'll wait 6 months, and then the claimant will be out of luck. I don't think the state set up this streamlined process in order to make those types of traps for people that otherwise facially fill out the form that the state gave them as the form is submitted and as the form requires.
Did the state do any discovery in this area? Usually they write letters, informal or formal discovery, send us all your medical bills.
On the file that I've reviewed in this case, Your Honor, I saw no inquiry by the state or no exchange of information.
And was there any reason which would prevent the state from doing that in this case? If they had a question or ambiguity about who was making the claim?
No, there would not have been, Your Honor. I mean, and in that regard, back to Justice Mansfield, in this case, too, the state could have directly called the attorneys. They wouldn't have had to have, state assistant attorney generals could have directly called the attorneys. That was a phone call away.
Have we ever held that substantial compliance with the tort claims claim form is sufficient?
I don't think, not to my knowledge, but I mean, I know of no case that says that, a state tort claims administrative form is going to be treated like a letter of credit that requires strict compliance. I mean, there's no case out there that says we're going to strictly construe these claim forms. The question that we have is, does it, and it's right in the administrative code, does it give the state the sufficient information?
Well, Counsel, we have applied substantial compliance in the context of whether the entire administrative process has been complied with. I mean, for example, Kleitz and Allendorf, both are cases in which we have approached the analysis as to whether there was substantial compliance. In Kleitz, for example, there's failure to withdraw the claim the 6 months has passed, failure to withdraw the claim, and the suit was filed. And so the question is, well, you didn't withdraw the claim before you filed the lawsuit. Is that fatal? And we analyzed it from the standpoint of substantial compliance, right?
That's correct. I was thinking, I interpreted Justice Waterman's question probably too narrowly, in the sense of interpreting it, must you have the status to make the claim? I thought that you were asking me a status question.
My question was limited to
Justice
the
Hecht,
claim
pardon?
form.
We have not used the term substantial compliance, right, and said that that's sufficient. And, I mean, I think
But
that's
the claim form itself is supposed to be informal. It's just supposed to put the state on notice that there's this claim out there and give the state an opportunity through its administrative procedure to investigate the claim and determine if it can rapidly expedite and settle the claim, or if it is not interested in doing so.
On the other side of the coin, though, if you read Colby versus Madison, I mean, Justice McCormick made it very clear. He put a chart in there about whose claim it was and whose claim it wasn't. And it's very clear that the post-death consortium claims belong to the estate. The pre-death ones belong to the spouse. I mean, what's so wrong about requiring a person making the claim to follow Colby versus Madison? I mean, the case is 20, 30 years old.
Yep, in an administrative context of a streamlined setting, and here we didn't have any pre-death damages because death was instantaneous. We can see that on the claim form. But it seems to me on an administrative one, Your Honor, I can understand why the party would need the status. A state's got to settle with the party that has the status.
Maybe, you know, the state was fooled into thinking that there was an administrator for the post-death claims, and the wife was making a pre-death claim. I mean, even if death is instantaneous, there's still some period of time before death occurs.
Well, there was no pre-death claim made, set forth in the state appeal form in this case. But also there was a funeral expense claim directly made in this case, which clearly it has to be brought by the administrator. I just don't see how the state possibly, when you look at what, in the informal thing, set down your claim, set forth what you're damaging in your categories, which is on page 12 of the appendix, the claim form, the state could have come to any other conclusion. In closing, if there are no further questions, in closing this, whatever one might say about the Voss case, and as contrasted to Gavin, it seems to me the last thing we'd want to do is expand Voss in district court cases on what it is based, such as Dyer and Peterson, to provide that it's one thing when a claimant doesn't have a status that is required in order to prosecute, settle, or collect on a claim. But it's quite another thing when a claimant, particularly in an administrative context, has that status from the beginning. Her status is not questioned in the administrative streamline level, and to lose her claim under these circumstances. Thank you.
Thank you as well, Counsel. Mr. Formaker.
May it please the court. Counsel. I'm Robin Formaker, I represent the defendant, State of Iowa. Listening to the arguments just now, and I'm going to address some of the various questions that were asked as I move around here. I'm going to depart from what I prepared in advance, but listening to the arguments just now, I want to remind the court this is an action at law. And what I hear from the plaintiffs in this case is, give us fireside equity. Give us...
I'm just saying, your own regulations say a claim shall state the name, address, telephone number, and age of the person making the claim. They did that. I mean, if you wanted more, why didn't you ask for it? The form doesn't ask for it, right?
The claim does ask for it, in my opinion, Justice Mansfield. It asks for the name of the claimant. And the claimant is the party that the state would be liable to if the suit is brought in court. The decision in Voss, which the plaintiffs spend a lot of time trying to distinguish the fact that in Voss no estate was open, whereas here, when Deborah McFadden made a claim in an individual capacity as found by Judge Phipps, there was a parallel estate proceeding going on in Polk County. That really is immaterial, because in Voss, the guiding principle that I think answers your question and that transcends the facts in Voss and applies here as well is found in the opinion at 553 Northwest 2nd, jump site to page 881, where the statement is made, quote, "Therefore we hold a claim is defective if it is not made by a claimant to whom the state would be liable for the damages sought." So the question becomes...
I mean, so you're saying, go ahead, I'm sorry.
No, go ahead.
You're saying when it asks for name, and she wrote, or the attorneys wrote, Deborah McFadden, they weren't providing what the state asked for?
They weren't providing what Voss asked for, the name of the claimant to whom the state would be liable for the damages sought. The state's not liable to the individual.
The problem, I mean, that is distinguishable, that in that situation, the plaintiff was not the administrator at the time. The plaintiff didn't have the legal capacity, right?
But that's a difference. Yes, there was that fact element in Voss. I'm saying that the holding in Voss, as the Court of Appeals found, as Judge Phipps found, transcends that case and applies here as well. Because
It's not clear to me.
Mr. Formaker, Rule 1201, which is the real party in interest, which is so requires it to be brought in the name of the administrator, not the estate. The name of the administrator is the real party in interest, who brings it on behalf of the estate. So how is that not consistent with just putting the name of the administrator on the claim form?
Because the name of the administrator, as it was set forth in the claim, as found by Judge Phipps, as the Court of Appeals agreed, was simply the name of an individual. There was no indication. You couldn't look at the claim submission that was made here and discern that an estate proceeding had been opened.
And Rule 1201 goes on to say that claims shouldn't, and maybe that's a different statute, but it says claims shouldn't be dismissed if it's not fully disclosed at the party. You have time to substitute the right party, and your time is okay. I mean, you're making the administrative proceeding sort of like trial by ambush, where our rules of civil proceeding sort of take care of this situation.
Well, number one, you're citing rules of civil procedure that I don't think apply to the claim form. I mean, we're talking about the administrative stage. I realize the plaintiffs in this case have even invited you to somehow use their petition to relate it back to the claim form. I don't see how that works.
Tell me how you were prejudiced or how you were fooled when somebody brought a name with a name and they didn't have the estate on there, but you knew they were for post-death damages. You understand Colby. So the state, you would agree with me, the state had to know it had to be brought by an administrator.
Well, a wrongful death claim has to be brought by an administrator.
And
there
so
can
how
be,
is
as
it-
you alluded to earlier, pre-death claim brought by the individual.
How was the state fooled or misled in this case when the name administrator was on there when she was in fact the administrator?
The question of whether or not the state was prejudiced or fooled is really immaterial, Justice Wiggins, because we're talking about subject matter jurisdiction.
But
Well, I think I'd like to dissent respectfully from this characterization of this as
in
necessarily.
this case, you can't dissent. That's your one forum to do it.
I'd like to, I'm still going to try to proceed to dissent respectfully from the notion this is a streamlined process when you're talking about the initiation of the claim itself. We're talking here about subject matter jurisdiction. The cases that Justice Heck alluded to, and I can cite others, there has been
But, I'm not maybe on board with the notion that substantial compliance or the college try is enough. But as I read the form, here the claimant complied with what the state asked for. It says, name of claimant, please print full name. There's no place on the form, there's no place on the rules where you ask for the capacity.
This is name of claimant. The only proper claimant that could bring the wrongful death claim, once we take a look at the petition that got filed down here in Warren County, would be the administrator for the estate. What was filed here, what we're getting is this
Is that
pitch
a
for...
question of capacity? I mean,
Yes.
well,
Yes, because the state can't be held liable and found to be liable, as Judge Phipps found, as the Court of Appeals found, to the individual.
and that's correct, of course. But yeah, I mean, Ordinarily, we distinguish between capacities. I mean, in a pleading, we say, you know, Mr. X in his capacity as trustee or his capacity as executor or whatever the capacity is, but the name remains the same. I mean, I think that's, I may be building on Justice Mansfield's point or maybe making a different one, but the name was correct. Now, capacity wasn't stated. I mean, that's undisputed, I gather. On the other hand, from the four corners of the document, you knew what the capacity was.
I don't know what the capacity is. The only capacity I can discern from the claim form is it was filed individually.
Your Formaker,
Ask
if you,
for it.
if
I'm
you,
sorry, go ahead.
Yes,
if you look at the petition filed, it wasn't brought in the name of the estate. It was brought in the name of Deborah E. McFadden, as the rule of civil procedures require. It says Deborah E. McFadden, individually and administrator of the estate. It was brought in her name. It wasn't brought in the estate's name. It doesn't say the estate of Charles McFadden Jr. brought by the administrator, and that's what our rules of civil procedure require. So it was brought in her name.
it was brought at the appeal board, or strike that, at the administrative stage, used to be the appeal board stage, by Deborah McFadden in her individual capacity. The petition tracks with that part of the claim where it says Deborah McFadden individually. Frankly, the petition provides evidence to support what the district court found here. There's no statement of estate status in the claim form. The estate appears for the first time when the petition is filed, and the petition...
Where is it required under the state statute or the rules? And I think that's Justice Mansfield's question, which you haven't answered yet.
I'll answer it right now. The definition of a claim under Iowa Code Chapter 669, and throughout the provisions of 669.2 through 669.4, imposes liability in those instances where the state has waived sovereign immunity, in instances where the state would be liable as if it were a private person. That's where Voss comes from. That's where Voss gets its manifestation of its decision, where they hold that in order to perfect the claim under the Iowa Tort Claims Act, it has to be brought, and it's a jurisdictional requirement. So prejudice, consent, estoppel, that doesn't apply here.
But Voss is distinguishable because there was no claim set up at the time, no estate set up at the time they did it.
That
doesn't make a difference to you.
It does not, because the principle here, why don't you put the name then of the estate in? They had counsel.
Counsel, yeah, I think we've exhausted that point. We know your position, I just want to move on to a slightly different type of part of the analysis.
Sure.
And it's this. Your argument suggests that, well, we didn't know there was an estate open, or we didn't know she was the personal representative for her deceased husband. But you did know from the face of the claim form that this was a wrongful death claim, right?
Yes.
I mean, it's right there on the form, and that's where she enters her damage figure. And so you also knew, as the Attorney General, that the only person under our common law and the interpretation of the relevant statute who can assert a wrongful death claim is the personal representative, right? So,
well, not entirely.
Well,
not entirely,
well,
because...
look, we disagree on that.
May I answer that a little more fully?
Well, in a minute.
Okay.
So my question goes to a question I posed to your opposing counsel a moment ago, and that is, what about this administrative process should permit the Attorney General, representing the state, to lay in the weeds and not ask the question, do you, Mrs. McFadden, have the capacity, the authority to assert the wrongful death claim that you put on the face of your claim form, and just sit back and wait to see if she wakes up and says, well, I am the administrator, and therefore I have the capacity under Voss to assert the claim. What about the administrative process should lead us to believe that you should be able to just lay in the weeds and say, she didn't say she's the administrator, so we're going to assume she's not?
Okay, there's nothing in the administrative process here that suggests there's a laying in the weeds, Justice Hack. What is required is for...
Oh, you didn't inquire, did you?
There's no obligation to inquire. First of all, to go back to the question I was going to start to answer a minute ago, I'd like to take the chance to do that. it doesn't necessarily mean that the claim is going to be brought by the estate. There could have been an assignment of the claim to the individual. There could be the pre-death claim that Justice Wiggins hypothesized. You're talking about subject matter jurisdiction, and we're in here talking about fairness. Did we get it close enough? It's almost as if the inquiry is they ought to be deemed to have gotten it right because they could have gotten it right if the estate had actually filed the claim, but for the fact the estate didn't make the claim. It was made by Deborah McFadden individually.
Well, haven't we approached the question of substantial compliance and prejudice in Kleitz, where the alleged problem with the exhaustion was, hey, you didn't withdraw the claim and you went off and sued us.
I don't know of any case where this court has said that the initiation of the claim process is watered down sufficiently that we can just say close enough for government work, that's good enough, we're going to let that fly. You've had cases like Kleitz where they've said the lawsuit is the substantial equivalent of the withdrawal. You've had cases like Schneider.
Why don't you just answer me this question? Because file the claim, who looks at it? Where does it go?
Well, it gets filed down here at the Department of Management through the State Appeal Board. It gets routed around through various offices there and eventually to the Attorney General's office.
Okay, so you have at least, you've just given me a list of about 3 or 4 people that once this thing gets filed, that's what this agency is set up to do, is to look at these claims, analyze these claims, and so I guess what you're expecting me to buy into is the idea that we've got, you've listed 4 or 5 different agencies and a number of different people who are going to look at this, and then nobody does anything and waits for 6 months before then, or just does nothing. I guess they just look at it and say, well, I don't know, so we're just going to dump it, or what?
Justice Zager, as I'm fond of saying, I was born at night, but it wasn't last night. I've been doing this for many years. I can tell you we've settled claims at the State Appeal Board stage or at the administrative stage on a number of occasions. I've even settled them with at least one member of this court that I'm looking at here today. And therefore, it's not a situation where the claims are just, I can't tell you that they're all exhaustively examined. The claim was withdrawn by the plaintiffs, as they had a right to do, but the claim was not denied. It was withdrawn on May 29, 2014, and the suit was brought the next week. But I can tell you that the claims process has been used, at least in my time, I can tell you from personal knowledge, on a number of occasions. And we have settled claims. I settled one here I can think of even a year ago at the claim stage, and it's not a situation where we're sitting around and trying to lay traps for the unwary. My argument here, and I'd like to, if I could, just make this point. This is subject matter jurisdiction. It can be harsh. You file your notice of appeal 31 days later, and you intended to get it in within 30, and the appeal gets dismissed, as we learned last week in a case that came down from this court. Now,
as someone who dissented in
yes,
this
understand
case,
that.
What? And I've also dissented from some of our cases on the sort of close enough for government work or substantial compliance theory. But again, at the risk of getting in that area that Justice Hecht, I agree with him, has been fully explored. Didn't Deborah McFadden comply with providing the information you actually asked for and the rules actually asked for? There is not a question about capacity.
The name of the claimant, implicit in that, is capacity. To make the claim that the state could be liable, it has to be brought by the proper party. That's what Voss is talking about. And it doesn't matter whether an estate was open in Voss or not. That principle, we hold a claim is defective. It is not made.
Could I get in? I got that point at least by the 4th time it was said. But are we bound? You began by noting this is a law action.
Yes.
Are we bound by Judge Phipps' factual finding the claim was made by her personally?
Yes, and that's the point I'd like to sum up with. I wanted to start it with originally, and I said I was going to divert. This is subject matter jurisdiction. If you go back decades, back to when we still had the special appearance as a device for challenging subject matter jurisdiction, you'll find that the court is obligated to not send it to the jury, but to make its own decision as to whether or not it has jurisdiction of the subject matter. And the findings that it makes, against which it measures and applies its conclusions of law, have always been deemed to be binding upon the appellate court so long as there is substantial evidence to support the finding. And here you've got oodles and gobs of substantial evidence to support the finding. The claim was submitted. The claimant should have been the administrator of the estate. As I said, I've been doing this for 31 years, and they say, well, there's something unique about this case in their briefs. Well, normally I see the administrators filing them. I don't know if there's an assignment here. I don't know what the situation is, just looking at the claim form. But and by the way, there's nothing that limits these claimants to the claim form, Justice Mansfield. There's nothing about that form. It can be in other forms if you look at the administrative rules. They could have, the plaintiffs could have, if they wanted to, asked for an actual evidentiary hearing on the matter of subject matter jurisdiction under the Tigges case, or however it's pronounced, Tigges versus City of Ames. They could have asked for that. They did not. And the question for this court, as Justice Waterman alludes to, is, were there facts before Judge Phipps that would allow him to reach the conclusion he did? And I submit there were plenty of evidence to support his conclusion.
Can I ask one more question, Chief, and I promise it won't be the fifth iteration of that one I've asked before. Why do you talk about substantial evidence? We're just talking about reading documents. I mean, we can read the documents as well as Judge Phipps, right?
Because the case law over the years say at actions at law, and particularly with subject matter jurisdiction, that the facts as found by the judge are binding upon this court. In fact, it's no different than that principle in the rules of appellate procedure, where you list all of them that say they're so obviously accepted you don't even have to cite authority to support them. In 6.904, an action at law, findings of fact, are to be binding on this court if supported by substantial evidence. And you could have a judge that might have concluded otherwise about what was presented. But to say...
Might be a legal issue. The legal issue would be whether statement of the name is legally sufficient to satisfy the Tort Claims Act.
It seems to me the legal issue is once he found that this was a claim made in an individual capacity, because it said Deborah McFadden. We've cited copious authority in the briefs. If you want to claim representative status, you have to designate it. There's nothing radical about that notion. Once he found that, Justice Apple, then the only conclusion or the only legal question is, did he apply the right law? Was, in the words of Voss, it doesn't matter the distinction between the estate being open here versus the estate in Voss. Was the claim made by someone to whom the state would be liable for the damages sought? Once he found this was made by Deborah McFadden individually, he reached the right legal conclusion, as did the Court of Appeals. And we ask that this court affirm both those decisions. Any other questions? I'll be happy to answer. Otherwise, I see the red light here. Thank you.
Mr. Formaker, thank you as well.
Thank you.
Rebuttal argument? Mr. DeVolder, let me start you out with a question, if I could. The state's argument seems to be that this is a strict issue of jurisdiction, and which is the authority or the power of the court to hear this case. And one of the jurisdictional hurdles is the statutory requirement for the person that, or the entity, or whoever has the claim is to file it pursuant to the statute. And so the state is saying they're not laying in the weeds. This isn't anything other than the simple fact that the person who had the claim didn't file it. That's it. How do you respond to that?
With respect to the subject matter jurisdiction question.
Yeah, let's leave the form out of it. We all know that the person who really had this claim, the estate, in fact, did not file it under the statute.
I disagree with that. I mean, here's the
Well,
issue.
the administrator of the estate did not file this claim. Isn't that correct?
No, I don't think that's correct at all. I mean, the administrator of the estate is Deborah McFadden. She had that status. To acquire subject matter
Is that changing our law when we say that, if we say in this case that an individual can, for the purposes of filing a claim with the state, it's okay for an individual to file a claim, but when they go, if they file it in a law action, we require them to identify that the claim is not the individual, the claim belongs to the estate. So, I mean, I have all sorts of sympathy for the claim being made here, but I'm just trying to identify what the state's real argument is, and this was a claim of an estate that was filed with the state as a claim by an individual.
Well, it was, the claim belongs to the administrator, not the estate. The claim was filed by the administrator. The question here was not whether or not a factual finding was made on an individual, because this issue came up on a motion to dismiss. Your Honor, the problem with the state's argument is this. The administrator in this case, unlike in Voss, actually presented the claim. And what the state is trying to do is run away from its own regulations in claim form by coming up with the argument, and I wrote the exact word down that the state's attorney used, that it is implicit somewhere, either in the regulation or claim form, that when we have an administrator make a claim, the name of the claimant somehow requires a capacity write-down as well. The regulations do not say that, certainly explicitly. Where they say it implicitly even is beyond me, and it clearly isn't in the claim form itself. I mean, what the state's trying to do is use a semantics game, not a status game, not a status argument, which is the Voss opinion, Mr. Chief Justice, in order to really change the administrative procedure. They're making, buying the state's argument, actually, I mean, even in courts of law, we're a notice pleading state, Cooksing, etc. What the state is arguing here is that with respect to an administrative procedure on its own form, which should be more lax, is somehow moved to even a greater standard than simple notice pleading, which under any stretch of the imagination on the state's claim form they had. It is not a status problem, and therein is where the state is clearly misreading Voss, as well as misreading cases that aren't Iowa tort claims cases such as Pearson and Drive.
What would be the result if Mrs. McFadden would have filed the law action the day before the statute of limitations expired, in the same way that it was filed with the state, where she just would have filed it in her, just naming herself as the plaintiff? And on a non-ITC case, like she was suing another driver, a private driver that caused the accident. She says, Deborah McFadden versus private driver. And she did it one day before the 2-year running of the statute of limitations. Well, under Dreyer and Pearson, I'd ask this question. Did she in fact have the status of administrator prior to the time the 2-year period expired? If she had that status, she's probably going to be okay. But the problem with the other cases, in every applicable case, wasn't this implicit or how clear. It had to do with the utter absence of the required status. What the state is asking for is a huge expansion, not only of administrative law of a streamline, but of our law in courts as well, which is just unsupportable. Thank you. Thank you as well, counsel. The case then is now submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.